Kathy. I hope you're doing well. This early hour of the morning. Poor Carolyn has to go to work right now. It's 4:45 in the morning. Oh, there we go. There we go. Hi, Fozzie. All right, we're going everywhere today. We're going to Wisconsin. We're going to New Jersey. We're going to Indiana, I think. I'm not 100% sure I had that clipped out. And, of course, we're going to Harris County. Hi, Shauna. All right. Let's start with, okay, New Jersey law. I don't know if I explained it really well yesterday. So we're going to have the judge explain. No, I'm not muted. You can't hear me? Oh, no.
Can you hear me now? I think you can hear me now. Someone tell me. I just unplugged my microphone and put it back in. That always works. Let's see. Hi, Politically Pink. Hi, Shauna. Hi, Stink Guy. Hi, Fozzie. Hi, Carolyn. Hi, Joanne. Can you hear? There we go. Fozzie got me. Thank you, Fozzie. I must have had to unplug it and plug it back in before I start today. Okay. Let's see. Let's start over. We're going to New Jersey. We're going to Indiana. We're going to Wisconsin to a new courtroom. And of course, we're going to Harris County, Texas. Listen, I did what I was told, Kelly. I put it in the Discord and I did it on my YouTube. I don't know why. But we didn't start yet. So I don't know if I explained the hi Tammy. I don't know if I explained the New Jersey law really well yesterday. So we're going to start this clip with a New Jersey judge trying to explain how there is no bail in New Jersey anymore. You can't like bond out. Oh, thank you so much politically. I appreciate it. Don't worry, give me time. Okay. So here, let's listen to this judge explain it.
Mr.
Because
Martinez,
it hasn't been in trouble in so long. I don't
Mr.
see why.
Mr. Martinez, you want me to explain to you how the system works? I can. Okay. Here's how it works. There's no bond or bail in New Jersey anymore. Okay. It's either you're detained in New Jersey without any bail or you're released on conditions. The prosecutor makes the first decision. So the prosecutor now has made a decision that they've moved to detain you. I don't have a choice in terms of whether I release you or detain you. Once the prosecutor moves to detain you, you are automatically detained, and there is a hearing before a judge in Superior Court. And I'm going to tell you about that in momentarily. That's how the system works, sir. Okay, now, will you want to hire a private lawyer for your detention hearing, which is going to be on April 18th, or do you want to use the public defender's office?
Well, I don't. What's today's date? Just because I've been here for a few days.
Today's the 14th, sir.
Okay, so it'd be Friday.
I'm sorry, today's the 15th. My bad. Today's the 15th. Today's the 15th.
So then that would be a Saturday. So I'd have to
Thursday.
be here
No, just Thursday.
Thursday, sir.
Thursday.
Today, the hearing is Thursday. Today is Monday, the 15th. I gave you today. I thought it was the 4th. It's the 15th. So your hearing is Thursday.
Okay. And then is that possible hearing determine if I could be released on
That's
that?
correct.
So,
That the Superior Court judge will determine whether you're released or you're held, and there'll be an attorney. That's why I want to ask you, do you want to hire a private lawyer or do you want to use the public defender's office for that hearing?
I cannot afford an attorney at the present second.
All right, so somebody from the public defender's office will be contacting you within the next few days to prepare you for the hearing. As a result of the state's motion to detain, this court hereby remands Mr. Martinez back to Mercer County Correction Center to appear at detention hearing on April the 18th at 9 a.m. All right, now that does not conclude Mr. Martinez's matters because we have to serve him with a TRO, but we have to go off the record.
So I hope that explains it better than I did. There's no bail or bond in New Jersey anymore. You can't bail out of jail. You either get out or you're stuck in, and there's nothing anybody can do about it. Okay, this next clip. The judge is the star of this show, not any of the other people. She is on a dismiss this case roll. All she's doing is dismissing cases left and right. I thought it was so funny. So I just clipped her dismissing cases.
Right, sir. So the Office of the Attorney General is a petitioner in this case, and they have no opposition to dismissal. And you have no pleadings on file, and neither does Mr. Pierre's client. So this case is getting dismissed, okay?
I won't understand why.
I just explained to you in the last 4 sentences prior to me claiming
Yeah,
it's
but
getting dismissed.
I understand that, but you're just dismissing the case for for what? I wasn't told by a judge to do something all these years. So why is it getting dismissed? Would you dismiss it if I owed and if I was on the other side? That's why I don't understand this.
Yes, I would. If you had failed to follow the Texas Rules of Civil Procedure, I would dismiss it.
How did I fail to do anything?
Well, you know what? As the judge, I can tell you that you have failed to follow the Texas Rules of Civil Procedure that required you to file a cross pleading. And the Office of the Attorney General is dismissing their suit. So that means there's no live pleadings for me to hold a trial.
Okay, man. I just wanted to understand because I just feel if I was on the other foot, I wasn't told to do something by a judge all these years ago. I don't feel that I had to do anything, but that's fine. That's fine, ma'am. I'm just saying I don't feel that I wasn't told to do something by a judge, so I don't feel I had to do anything but sit here and.
Mr. Olvera,
I understand. Yes, ma'am.
I think it's a common misconception that a lot of people have that the court provides you a step-by-step process. That's, as you have now learned today, not how it works. You represent yourself and you have to act like a lawyer and do as lawyers are required to do. But I understand that that was a misconception, okay?
Mm-hmm. Yes, ma'am.
All right, you guys take care.
Thank you, Judge.
Yes.
Thank you.
Next up, Office of the Attorney. And there is like a significant issue health-wise for Ms. Benton. And I understand there's no appearance on file. But I'm just telling you, Ms. Young, I would not proceed on a default basis after hearing that she's hospitalized.
Judge, as you know, we're here the last time and she was hospitalized. I understand we've been trying to contact her. But
I have not.
I'm sorry, Judge. I'm announcing ready, and of course, we have to abide by whatever the court says.
Attorney General present on this, Judge. This is Mr. Jones's motion to modify. We are operating under temporary orders, which is in place already. I think in that temporary orders, and correct me if I'm wrong, Ms. Young, Mr. Jones was granted conservatorship. Is that accurate, Ms. Young? And
yes.
Last time we were here, Judge, it was a trial setting and the court reset it to today because Miss Benton was in the hospital. So this is...
That's not true. The court reset this because Ms. Young had issues with her notice and the court could not proceed on a default basis. If you see my docket entry made on January 30th of 2024, it states that Ms. Young was present. There's issue with notice, and therefore trial is reset to April 16, 2024 at 9 a.m.
Yes, Judge, I remember that as well, but Miss Benton was in the hospital at that time and she notified the OAG, and the OAG just expressed to you that she was saying that she was in the hospital and there was the notice issue. So we're here today for trial, and we're, of course, going to abide by whatever the court says, but we're just announcing.
So I'm ready to dismiss the suit because your notice is defective again. The hyperlink located on the notice that was filed on January 31st of 2024 is incorrect. So either it gets reset or dismissed.
We'll get a reset, Judge.
Anybody present? All right, no appearance, case is dismissed.
Judge, maybe hold on that. I don't have that on my list.
No, I'm gonna dismiss it. It's a private enforcement. All right. I know that this is a parentage filed by Mr. Brown and the OAG is the intervener, but I don't see notice of final trial, Mr. Brown, that you sent to all necessary parties.
Well, the lawyer did that before he got off the case. So that was sent, She told me the other day that she received it, and she alerted me that we were supposed to be in court today. So she has it.
Well, I believe you, but the file does not reflect that. I have no reason to doubt you would tell me differently, but the file does not show that notice was sent to Ms. Barlow.
Okay, I don't know.
Okay. Well, because of that, the case is dismissed. No announcement, case is dismissed. No announcement, case is dismissed. No appearance by petitioner, case is dismissed. No announcement, case is dismissed. All right, this case is on hold. I see the petitioner requested a bench warrant as he's an inmate and there is service on respondent. So I'm placing it on hold. Ms. Beard, we're gonna have to issue a bench warrant for him to finalize his divorce. Christopher Sepulveda, Tiffany Molina Canales, cause number 2023-22727.
Good morning, Your Honor. Attorney Angie Mendoza-Gwynn, present for the respondent counter petitioner, Ms. Tiffany Canales, who is present via Zoom. Your Honor, we would be announcing ready on our part. However, opposing counsel did yesterday file a motion for continuance, and he has attempted to file a motion for withdrawal of counsel actually several times. He did communicate with me yesterday that he is in-person hearing in Montgomery County this morning, and he will try to log on as soon as he can. And as far as a time estimate, Your Honor, if we were to move forward today, it would be 3 hours.
Okay.
Good morning, Your Honor. My name is Christopher Sepulveda. I'm presenting myself.
Kind of, not yet, Mr. Sepulveda. I think your attorney from the law firm has failed to file certain documents to allow you to represent yourself. So we have to wait for them to appear. So is it Attorney Okpara, Ms. Mendoza-Gwynn?
Correct, Your Honor.
Okay, have you heard from Mr. Okpara, Mr. Canales? No, Mr. Sepulveda?
I'm sorry?
Have you heard from your lawyer?
No.
Okay. All right. I also see there's a motion for leave to amend pleadings filed on your on your client's behalf, Ms. Mendoza-Gwynn. So does that lead me to presume that you're unopposed to their continuance?
Correct, Your Honor. If based on some certain things that happened recently is the reason we filed the motion for leave. And the reason that also, again, Mr. Okpara is re-urging his motion for withdrawal.
Okay. Mr. Sepulveda, do you want me to release your attorney and that way you can represent yourself for final trial?
Yes, please. I've been trying to relieve my law firm, the law firm that I hired for a while.
I understand. I think there's just been some hiccups that they couldn't do it successfully. But since you're in front of me and I have your request with Ms. Mendoza Gwynn here, I can sign off on that order now.
Thank you, ma'am.
Okay, so I'll do that. Which leads me to give you guys a trial date. So you'll be my first approach after the call of the docket, okay?
Thank you, Your Honor.
Don't log off, Mr. Sepulveda.
Yes, ma'am.
Joy Wally, Uche Wally, cause number 2023-33822.
Good morning, Judge. Attorney Papa J here on behalf of Ms. Wally. We are set for trial today. There is an MSA that was entered into.
2022.
Wow, this is actually the new case is 2023, 338.
Correct.
Yeah. So the MSA was from the case in 2022. And so
Correct.
we filed the MSA and we're asking the court to render a judgment based on that MSA pursuant to Texas case law.
Correct. And I couldn't do it because you didn't give all necessary parties a minimum of 45 days. There is a Court of Appeals case that says because it's a rendition of final judgment, I have to provide all parties 45 days notice. So that's why on March 1st, I couldn't render judgment. But
Right.
that does by no means prohibit your client to request the court to render judgment on an irrevocable mediated settlement agreement. It just has to be done correctly or timely, I should say.
Okay.
Is the respondent here?
Yes, Your Honor.
Okay. So what I can do is, since both of
Yep.
you are here, I can give a prove up an entry date of the
No.
MSA for a future date.
Yes,
Yes,
sir.
sir. I thought you
Your
go ahead, sir.
Honor, does that mean that the continuing of the case, or is that entering of the judgment? Because I've been out of work and I wasn't able to fund a lawyer, but right now I'm back to work. I want to get a lawyer to represent me in this case. And the case that I filed was dismissed, like you earlier said. And she filed a new case, which was initially on 507 court, and they moved
Okay.
it. And
All right. So you have a lot of legal questions I can't answer, but what I hear is that you're about to hire a lawyer because you just got a job and that lawyer can answer those questions. There's a lot of legalese and intricacies. Even if a case was dismissed, this is still a binding contract between you and your spouse that the court has to consider. If you have objections to that MSA, which is a mediated settlement agreement, then they have to be filed for the court to rule on. Okay?
but yes, I have objection to that, and that's one of the reasons that I want to hire a lawyer so he can file.
Sounds great.
Mr. Rose is on, Judge.
I'm here.
Oh, okay. I misunderstood. I
I'm here,
apologize.
but I would like to ask for time to find a job and hire a lawyer.
Did you file a motion for continuance, Mr. Rose?
I had a lawyer at first, ma'am, and then I lost my job, and of course I
Listen
lost
to
my
my
lawyer.
question. Listen to my question. My question was not, do you have a lawyer? My question is, did you file a motion for continuance?
Man, after I lost my lawyer, I don't know what happened. I don't know what she filed and what she didn't file, so I really don't know what's really going
Okay.
on that side.
What about you personally? Did you represent yourself and file a motion for continuance?
No, ma'am, I didn't. Not personally, no, ma'am.
All right. I'm going to send you guys to Judge Salfidi, and if you want to urge your continuance before him, you may certainly do so. But otherwise, you guys are going to trial today, okay?
Thank you, Your Honor.
Yeah. All right. What is the party's announcement?
Well,
I'm
my
sorry. Please go ahead.
understanding, I'm sorry, Ms. Gilder, go ahead.
No. You go right ahead.
My understanding is that Ms. Gilder filed a motion for continuance last night stating that respondent would not be here. And at this point, we're asking for the case to be dismissed.
Okay. On behalf of the state, Ms. Batoon, what is your response or I guess statement, if any?
No objection to dismissal.
Ms. Gilder, on behalf of your client, do you have anything else you would like to add?
Yes, ma'am. The reason why my client cannot be present is that he is currently a cadet in the Academy for the Houston Police Department. If he misses a day, he's kicked out. That's why he's not here. It is anticipated that the Academy will be graduating in July. If the parties, if the court were to dismiss the case, it would be against judicial economy. The only issue that is to be resolved at trial is whether Mr. Gomez receives an expanded possession order or not. Everything else has been resolved by a mediated settlement agreement.
All right, it sounds like he doesn't lose anything. He can always assert his right to render judgment on that partial MSA if that's genuinely a fact, which I don't doubt it is, coming from you.
Your Honor, and no offense to Ms. Gilder, but nothing else has been agreed to, no child support, nothing. So
Okay.
everything is still up in the air, and he knew about his cadet last time when we agreed on this date when it was reset previously. That's why we're asking for the dismissal.
So my problem is filing a motion for continuance the night before trial is not proper notice. There's that. And additionally, your client, Ms. Gilder, has known at minimum since January 30th of 2024 of this trial setting, which in fact was the reason why I reset it January 30th of 2024. So my extension of grace has come to an end and this case is dismissed.
Okay, thank you, Your Honor.
No announcement, case is dismissed.
She just dismissed everything. I was watching her, and she was really hard on the attorneys. If they didn't file the exact. Okay, so the one attorney had the one wrong hyperlink in her paperwork, and that was it. That was enough for her. She's like, nope, we're not going forward with this. I love her. I love how she did that. I just can't remember where she was from. I think it looks like she was from Indiana, or Wisconsin, but the accents don't match Wisconsin. So I'll have to look her up and try to remember where I got her from, because I just don't remember. All right. We did the New Jersey. Okay. Let's go to Indiana with Judge Link. I called him Judge Fink once because I can't read that tiny little letter. But here's Judge Link. He's not the star of the show, is
Sit up as
this
close as
guy
you can
is.
so we can hear you, okay?
Pardon me?
Just sit up close so we can hear you on the microphone. There you go.
State of Indiana versus Edward Ruffino, 46D04-2404 CM837. Show for the record, Mr. Ruffino appears by video with counsel by video for initial hearing. Mr. Ruffino, did you see and hear the video advisement of your rights?
Yes, sir.
You understand what your rights are in this case?
Well, sort of, but yes.
Well, it can't be sort of. It has to be yes or no.
Yes, sir.
You need me to go over your rights with you today?
No, sir.
Do you have any questions about your rights today?
Yes, sir. About what happened.
Meaning why you're sitting in jail, or what are you asking?
No, never mind. I'm okay, sir. I'm just confused a little bit.
Okay. Well, you ask me questions. If you need to, I'll try to explain things to you, but I need to make sure you understand your rights in this case.
Well, I understand my rights. Yes, sir.
Okay. What is your current address?
1692. But I live in West.
Where does your mail go to?
Michigan.
And do you have a cell telephone number?
Yes.
All right, sir, please listen. Mr. Fredoso is going to advise you of the charges and the potential penalties.
Thank you, Your Honor. There are 2 counts alleged in the charging information, and both counts are operating while intoxicated charges. The 2 charges are filed in the alternative, which means you cannot be convicted of more than 1 operating while intoxicated offense under this clause. Count one alleges that on or about the 14th day of April 2024 in LaPorte County, Indiana, Edward Rufino did unlawfully, knowingly, or intentionally operate a vehicle while intoxicated in a manner that endangered a person. That count is a Class A misdemeanor. Class A misdemeanors are punishable by up to 1 year in jail and a fine of up to $5,000. And the second count alleges that on or about the 14th of April 2024 in LaPorte County, Indiana, Edward Rufino did unlawfully, knowingly, or intentionally operate a vehicle while intoxicated. That count would be a Class C misdemeanor and is punishable by up to 60 days in jail and a fine of up to $500. Any conviction for an operating while intoxicated offense is considered a major traffic violation by the Indiana BMV for purposes of Indiana's habitual traffic violator law, and it's also further punishable by driver's license suspension.
Mr. Rufino, do you understand each charge and the potential penalties for each charge?
No, sir, I don't.
Okay, what don't you understand? I'm not asking you if you agree with the charges.
Oh, okay.
I'm asking you if you understand what you've been charged with.
Yes, sir, I understand.
All right, I'm entering preliminary pleas of not guilty on your behalf to all charges in this case. You're going to need an attorney, Mr. Rufino. Are you able to hire your own attorney?
No, sir.
Are you employed?
Seasonal, sir, yes.
What do you do for a living?
I work for a carnival, sir.
He's a carny, guys. I was so excited when he said that. He's a carny. Let's all join him. Let's all just run away and join the carnival. Wait till you see how much he makes at the carnival. Hi, another. Hi, Stink Eye.
You work for a what?
Carnival.
Carnival.
North American Midway Entertainment, but the name of the company I work for is BAM Concessions. I work on the games, sir. That's pretty much it.
When does your season start?
Friday.
How are you paid? By the hour?
No, sir, commission. I get 25% per week. Whatever I make, I get 25%.
From the particular game that you run that week?
Yes, sir.
A carny, Sarah. That's what we call anybody who works for a carnival. We call them a carny because they're special. They're very, very, very special people. Hi, KS.
Approximately how much do you average a week when you're in work?
The highest I made is probably $12,000 in 7 months.
Are you married or single?
Single, sir.
Oh,
Do you have any children age 19 or younger?
No, sir.
Do you own any real estate?
No, sir.
Do you have a bank account with any balance in it currently?
Yes, sir.
What's your approximate balance?
Probably about $1,500 now.
And you earned that from your work from last year?
Did you earn it from your work from last year?
Yes, sir.
All right, Mr. Rufino, I'm finding that you're indigent. I am appointing you a public defender. Mr. Reynolds, anything on behalf of Mr. Rufino?
Thank you, Judge. After consultation with my client, we are in agreement with the pretrial service recommendation of recognizance release at a level 1.
Thank you. Anything from the state?
Thank you, Your Honor. Nothing from the state.
Thank you. Anything from pretrial?
Yes, Your Honor. This morning when the defendant was interviewed, he gave the same address that he gave the court, but he stated it was his current living and mailing address. So I was hoping he could confirm what his actual residence address is for our records.
Yes, he's asking.
Okay.
Okay, so what is your current address in Westville?
That's where I live.
Okay, thank you.
All right, Mr. Ruffino, I'm going to release you on your own recognizance, which is your promise to appear at all future hearings in this matter, with the condition that you're ordered to participate in pretrial services at a level 1 supervision. Before court today, did you sign the written conditions of pretrial release?
Yes, sir.
Did you read that document before you signed it?
Yes, sir.
You understand those conditions?
Yes, sir.
Do you have any questions at all about those conditions?
No, sir. But I do have a question for you, though.
Go ahead.
Okay, is it possible if I'm for the license suspended that I can get a hardship license? Do I talk to the public defender about that?
You'll have to talk to your attorney about that.
Okay.
I'm not sure if you're eligible for that.
Okay.
There is another option. You can have the ignition interlock. That is an option under the statute, but you'd have to talk to your attorney, have your attorney. Yes, sir.
Okay, my car is in pound. Is it possible that I can get some stuff out of the car?
That's up to the impound yard. I believe it's typically the impound yard's policy to allow you to get personal effects out of the vehicle, but that's up to them. So if they tell you no, then you're not allowed to do it. No.
Okay, thank you, sir.
All right. So after today's date, all of your court's going to take place in Michigan City, in the Michigan City Courthouse on the 2nd floor, in the magistrate's courtroom for Superior Court number 4. I did appoint you a public defender. The public defender's office is going to send a letter to you at 1692 West, 850 North, Michigan City. That letter is going to tell you the name of your attorney and have your attorney's contact information. As soon as you receive that letter, you need to make sure you contact your attorney. Your next court date is going to be June 17th, 2024 at 12:45 p.m. You are ordered to appear in court in person on that date. Again, you should hear from your public defender before that date. Now, you travel for work, correct?
Yes, sir.
Do you travel the lower 48, or how far do you go for work?
Okay, for the first couple months, we're in Indiana. We go to Michigan. Then sometimes we go to South Carolina. I mean, it changes every year, believe it or not, sir.
Okay, so I'm going to allow you to travel for work purposes only. Normally, under those conditions, you're required to stay in LaPorte County. So you can travel for work only. Any other reason for you to travel outside of LaPorte County, you'll have to get permission from the court before you do that.
Oh, wait, can I ask a question?
Yes, sir.
I can work, I didn't understand that a little bit. Now, can I travel? I have to ask the judge if I could travel out of state after Indiana?
No. You're not allowed to leave LaPorte County, Indiana, except for I'm allowing you to leave for work purposes.
Okay.
If you need to leave LaPorte County for any other reason, you have to get permission from the court before you leave.
Now, see where I live, sir, in the carnival, stay in a bunkhouse, and it's on their grounds. Is that okay?
That's fine, as long as you're there for work.
Yes, sir. Thank you very much.
All right. I'm also ordering that you call pretrial no later than 3 o'clock tomorrow, Tuesday, April 16th, 2024. At the bottom of the written conditions of pretrial release is the telephone number for pretrial. So you're going to call them and you will get signed up for pretrial, and they will explain to you the requirements of a level 1 supervision.
Okay, thank you.
You're welcome. Do you? It's in the wedge, so it's not alcohol. Do you have any questions about any of the information I provided to you today?
No, sir. You've been very helpful.
All right. Do you understand if you fail to contact pretrial by 3 o'clock tomorrow, Tuesday, April 16th, or you fail to comply with your level 1 supervision requirements, your release in this case could be revoked and a warrant could issue for your arrest?
Yes, sir. I understand.
All right. You're excused. Thank you, sir.
Think I was gonna say they don't have bumpers. Oh man, I love cornies. I love them. I love them. I love them. Okay, we're gonna go to three different cases real quick in Wisconsin. So the first one, I cut the whole beginning out because it was long and boring and lawyer talk and nothing happened. Um, but it's a child abuse case, and it was from 2 years ago. And she applied for a public defender 2 years ago and qualified and still has not got one. She still has not gotten a lawyer. Now, she's in custody right now, but she has not been in custody for those 2 full years. She's just in custody because she caught more cases. So now you're caught up.
It doesn't seem that she's dangerous to the community. I've talked to her. She's going to call us and keep up to date with her court dates. We're asking for a signature bond.
Just to correct the record, she does have, I think it's 3 pending cases in Vernon County that I believe have occurred since 2022. So
look at the public
there's
defender.
more out there.
Thank you. At this point, the court will impose a cash bond of $500. The conditions on the original bond will be added to this cash bond. That includes on the felony case, no contact with KF and MF. I'm hesitating because there was some issue. Okay, from what I can see at the current time, acknowledging it's been a couple years, the court has previously indicated if she wants contact with or no contact, she should address it through CPS.
I have tried and I've gotten nowhere with that. It's been almost 2 years that I've been wanting to see my son. But going through this is I've lost my partner. He died from kidney failure just this last October. I'm just kind of I don't know. I'm not familiar with the court system until this had all happened in 2022. I don't have.
Well, that's how an attorney could help you, and they're working on finding you one. I acknowledge that they haven't found you one yet, but certainly the warrants for your, hold on, the warrants for your arrest do not help in you getting an attorney, because an attorney looks at this case and sees, if the court can't find Ms. Sampson, how the world am I ever, as an attorney, going to find Ms. Sampson? So you need to stay in touch with the public defender's office, let them know when your address changes. More recently, about a year ago, Judge Bierke indicated, who's now retired, indicated the DA was to contact the step-grandmother to see if she wants contact by phone. Then the DA would notify Sarah about contact with step-grandma. And Sarah would be his judicial assistant. So I don't know if that ever happened, but that can still happen through the DA's office. Otherwise, once you get an attorney, they can contact step-grandma. There's also an added condition from June of 2023 that I'd like on this new bond. I'm sorry, that was for you to go to treatment. I don't know if that happened or not, but it doesn't need to be on this bond. So I'm talking to both you and the clerk. Mail from July got resent to a forwarding address. In August of 2023, Judge Gonzalez said you were to appear at the next hearing or your cash bond would be forfeited. So there is a history of non-appearance. That's the reason I'm ordering this cash bond. And hopefully the public defender's office will find an attorney for you. Thank you, and you're excused.
Exactly how long am I to wait for an attorney to represent me? I've got this case will go on. Is there a statute of limitations of some sort, or I don't know, something?
You have previously explored in the felony case representing yourself, and I think the ruling there from the court was that you haven't completed high school. You are probably ill-equipped to represent yourself, so today is just your appearance on a warrant. I am not, opining myself on whether you can represent yourself. I will continue this. You're in custody now. You have a felony case. I'm going to continue it for 2 weeks to May 1st at 10:45. That will be in front of Judge Gonzalez. And given what you've just told me, but given that I've just told you, you're charged with a felony of child abuse causing intentional harm. I mean, if at any point you want an offer, if at any point you want an offer from the DA's office, you can contact them in writing and ask for an offer. But at this time, that's a serious charge, and you have no obligation to proceed with this case without an attorney.
I agree. It is a serious charge, and that's something that's that breaks my heart. That's my son that I've raised by myself for 15 years. That I was trying to get to leave the step grandmother's house, and wouldn't leave with me. I grabbed his hoodie and I scratched his side.
Let's not confess to the crime in front of the district attorney's office. That is one reason you need an attorney, is because you're making choices which do not help you at all and probably harm you. Admitting that you grabbed him when you're charged with intentionally causing harm. So just don't make any statements without your attorney, and hopefully the public defender's office will find you one. You're not the only one in this situation where they haven't found an attorney when they have a conflict with the case and have to look toward the private bar to find you an attorney. I've set your next appearance. I've set your next appearance within 2 weeks, and I'm finding good cause to go beyond the time limits. Perhaps they will find someone now that they know where to locate you within the next 2 weeks.
Sorry, I just want to confirm that
My ex had died, and that's why I had moved, because of the place that I lived at.
What did she already post?
She posted 150.
Okay, my reading was that the 150 was to be forfeited. The clerk is asking me, you've already posted 150. If it has not been forfeited, then additionally, you'd need to post an additional 350. So that's an advantage to you. I'm not gonna, raise the bar to 650 total posted. If you post an additional 350, you've posted your bond that I've set in this case. Thank you.
No, thank you.
Obviously. We do have somebody calling in from a number that ends in 053. I'm going.
So I don't know if she lost her kid 2 years ago and she still hasn't gotten a public defender. I mean, I don't know if that was my kid. I mean, I would have gotten a lawyer. I would have gotten a public defender. I would have been loud. I would have gotten a lawyer that day. I would have gotten somebody. But she has other issues, obviously. Okay, the girl who did the stretch monster right in the middle of that video, don't worry, I got her too.
Now, we will acknowledge that she does not have any prior failures to appear at least. However, 12 pending files does indicate that she does not follow conditions of bond, cannot be trusted in the community. And I also think eventually that does also lead to a risk that she will not appear because of the disregard for other conditions of bond. Therefore, we believe that that amount of cash bond is appropriate given the number of cases despite whatever financial circumstance she has. As far as conditions, we are asking for the following. No contact with Brenda Y. or her residence. If she does post cash, we're asking for GPS to enforce house arrest conditions. No contact with Cassandra T. or her residence. No contact with the recovery room. No contact with Mary R. or Ryan R. or their residents. And also to comply with Justice Support Services bail monitoring.
Was Cassandra with a K or a C?
Cassandra's with a C.
All right, Mr. Mahalski, anything you wanted to state about those conditions?
Not about the conditions, except for I think $5,000 is excessive at this time. She's going to be public defender represented. She's been trying to find work and it's not been able to do that. I think that's a lot of what's leading to some of the problems that we're experiencing. I'd ask the court for a significantly lesser bond, if not a signature bond.
I have a job interview coming up with the district manager. I've already done one with the general manager of Burger King. I have one coming with the district manager. I have to schedule by Friday. If I don't make it in, I'm not going to get the job. I can't post a $5,000 bond.
We know that.
Can you post any kind of cash?
We know that.
I might be able to do like 3, 4. I'd have to call my mom, but there's no way I can do 5,000.
Okay. Ms. Colkine, at this point, the state is asking for a $5,000 cash bond. Your attorney is asking for a signature bond. I understand that you had something to take care of by Friday with regard to a job at Burger King. However, you know, you have these 4 felony and 1 misdemeanor cases coming in today. I do believe you're a risk at not appearing, and you have 12 cases total. So far, you've posted $200 cash. The court is going to order a $1,000 cash bond that would apply to these 5 cases. So it's the whole 1,000 you'd have to post. And if you do that, the conditions will be that you have no contact with Mary R. or Ryan R. or their residents, no contact with the recovery room, no contact with Cassandra T. or their residents, no contact with Brenda Y. or their residents, that you do Justice Support Services bail monitoring, which means as you leave the jail, you stop at JSS and begin bail monitoring, and that you be subject to a GPS for house arrest through Justice Support Services. Now, that would still allow you to work. If you got a job, you would let them know your schedule, and then you can be out of the house arrest to work. And for such other conditions as Justice Support Services sets. Now, in the meantime, if you don't post the $1,000 bond, then we know that you will be here for your preliminary hearing. But if you do post the bond, you need to make sure that you are here Tuesday, April 23rd at 11 o'clock for your preliminary hearings on the 4 felony cases we've discussed today. And you should meet with connect with Mr. Mahalski before that time. Thank you, and you're excused.
She has all of those cases, and she's posted like what, $200 so far, and she's complaining that she can't post 5,000. She's lucky she didn't get 5,000 on each of her cases. But yeah, that thing on her face is just you know, braces, just braces. All right, and of course we get this guy too, this guy in the top right. Yeah, yeah.
Westmore.
Your Honor, date appears by Jessica Skemp. I'm appearing personally in the courtroom.
Jacob Westmore appears by video from the La Crosse County Jail. Present in court is attorney Rachel Krieger. And then also by Zoom is attorney Joe Randke, who's adversary counsel on the competency matter, Judge.
Okay, thank you. To all counsel, this case is a little, I'm sorry, what?
If I'm not being represented by Tom LeConte, I would prefer to represent myself.
Yes, please
Mr.
do.
Westmore, I have some sad news for you. Mr. LeConte has retired after many years of service, and he's no longer a practicing attorney. Rachel Krieger is a member of his office. She's on staff with the Public Defender's Office, and she is well capable of handling this kind of case. Additionally, you have attorney Randke because this case came forward as a competency issue, and I think that issue actually was raised by Mr. LeConte. I could be wrong. But at this point, what I was going to say is that the court needs a little bit more information. It looks like one competency report came back and that perhaps another one was going to be requested. I'm not sure that other one was requested, and another judge put this on my 2 o'clock calendar for intake. So if we need to have a hearing, I need to know, are we first waiting for another report? And second, can we choose a date where we can focus on Mr. Westmore's situation and not have it heard at 2 o'clock?
Yes, Judge. Just so you know, an evaluation has been ordered. Dr. Stress is working on it. I sent a follow-up email. It's taken him a long time to get it ready. My understanding is that he anticipates having the report back to me by the end of next week, so by the 25th or 26th. So I think at this time we should probably schedule a hearing anytime that following week, whatever that is, the week of May 1st, off of intake, so that we can have a date when doctors can be available and we can have the hearing if necessary.
Okay, so Mr. Westmore, just to be clear, in case you didn't know or have forgotten, the report that's in indicates that you're not competent. The other one might indicate something different. So that's why we're waiting for that other report. I would be setting this in front of a different intake judge at that time. Let's see, 1, 2, 1.
Actually, Your Honor, and I'm sorry for interrupting, but I think we'd rather not have it on the intake calendar. We need an actual time for a hearing, probably an hour.
Finally,
for testimony.
An accent.
I think that's what Mr. Randke is saying, and that the state's in agreement with scheduling that.
Right, so we can set it at some time other than 2 o'clock, but it would still be an intake case because he is, well, let me look. Or it'd be in front of Judge Horn, who has the lowest number misdemeanor case. Lowest misdemeanor is 995, correct?
That is likely correct.
Completely based off of opinion.
That is accurate, Judge, and that one is assigned to Judge Horn.
All right, so he is the lowest misdemeanor case. Mr. Westmore is not charged with any felonies, so the parties can get a date in the time frame set out by Mr. Randke that both defense counsel and the state are available to dedicate an hour to Mr. Westmore.
Is there any chance that I could get scheduled quickly within 2 weeks? Otherwise, I might want to request a signature bond hearing if possible.
Okay, well,
Judge, if I may, Mr. Westmore and I did briefly discuss wanting to have a bond hearing soon. He has been in custody for an extended amount of time on these misdemeanors, some of which I would say are quite minor in nature, and he's on $1,000 cash bond. That's been since January 11th. And I believe that is all that is holding him while we wait for the determination on competency. But we could get that set sometime soon on the intake calendar if we do not want to wait until that hearing that we eventually get with Judge Horn. Unless you're inclined to change it today.
I am not inclined to change it today. I believe, have one of these misdemeanor cases, but some things have happened since my misdemeanor case. I think I did give him a signature bond at that time, and then there's been more trouble. I'm not inclined to change what is currently in place. I also don't know the status of the stress investigation, Dr. Stress, whether they'll want to meet with him before completing that report. So today I'm not going to remove him from custody. And the party should get a 1-hour competency hearing in front of Judge Horn, who has the lowest felony.
Misdemeanor, but yes, Judge, I'll send.
I'm sorry,
email,
yes,
get
the
scheduled.
lowest misdemeanor. I'm sorry, I misspoke. You're right, Mr. Ranke, and I had even said that. So yes, in front of Judge Horn. And then I think you might have a situation where some of these still need a initial appearance once the competency hearing is held. Thank you.
Thank you.
And then
Speaking of Judge Fleischer, it's time. It's time to show you what he did yesterday, which is still today for me. So I'm saying earlier today, even though it was way earlier yesterday.
And my feelings were confirmed. I sent you to get drug tested, and you came back and tested positive for cocaine and marijuana. I am now going to keep you extremely close to me. And if you don't take and dodge these demons, I'm going to do it for you. Do you understand? So we can do this the easy way, or we can do this the hard way. How that happens depends on you.
Hard
you
way.
hold the keys to the
Hard
jail
way.
cell. Do you understand? I will appoint your lawyer
Doesn't he look so nice today, guys?
today, but I'm going to have you come all the time to drug tests. And the first time you test positive, I'm going to put you into an inpatient facility in the jail. You understand? Take a seat for me in the jury box while we find you something. I don't know. Let's talk with the lawyer to find out what he does for a living, because I don't want him to lose a job if he's working. And then we'll craft something once we give him a lawyer.
Did we have one from yesterday's docket that fell to appear?
Yep. Oh, are you ready? It's come up, Mr. Harris. You are Zarnell Wesley Harris. Mr. Harris, you now stand charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 7, 2024, the complainant found the defendant on private property in Harris County, Texas, Lansford baseball field specifically, where he was inside the building used to sell concessions and also store equipment. He appeared to have used a unknown object forced entry through the door. The complainant stated that the defendant was issued a verbal and written warnings for criminal trespass. He was told not to return multiple times.
Do we have any evidence that he was trying to burglarize and take the equipment from the because those things, those baseball fields and those junkets have all types of things in there. You're very lucky that you're not charged with some kind of burglary of a building type case, which would be a felony offense, Mr. Harris. As it stands now, what did I ask you to do while you were on bond? Do you remember? I'm sorry? No. Don't pick up any new cases while you were on bond or what was going to happen. What's going to happen? Think. What's going to happen? To you. Sure. What else? You get your bond revoked and you go to jail. You were on bond for an interference, and now you've picked up the criminal trespass. Take a seat for me in the jury box. I'm going to appoint your lawyer today, and we will see where this goes. Do you mind reaching out to the man, please? Is there any? Nothing was solved. I'm going to find that there's probable cause. And I don't know what we're going to do.
Hey, what's going on? You got a minute? Yep. I got a guy who is, it's off docket, and he is on Friday's docket. He was asking me, could we move his, we might as well. Judge, may we approach? You're gonna overhear this anyway. I have a guy that came in to hire me off docket. He has a really important business thing going on Friday and Monday. His name is Stephen Garcia.
Bring him tomorrow.
Okay.
Tomorrow or Thursday.
He's on Friday.
Bring him early.
He's here now.
Perfect. We can do it right now.
Can I grab him?
For sure. Did you get the cause number?
No. That's what I was waiting for. That's set for Friday. Let's see.
Oh, yeah, that's a good idea. Let's go look on Friday, see what it is.
I'm bad about not giving cause numbers.
It is
Nathan always gets on to me for that.
250-5428.
Come on up, Mr. Garcia. Is it Steven?
Steven, but
Steven.
Steven, yes.
Is it Steven? Is that how you pronounce it? All right, Mr. Garcia, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you.
On April 13th, 2024, traffic stop was conducted on the defendant for going 84 and 65 in Harris County, Texas. Officer observed red, glossy, bloodshot eyes, slurred speech, and strong odor of alcoholic beverage from the defendant. Defendant admitted to drinking 3 beers. SFSTs were conducted, 6 out of 6 HGN, 6 of 8 walk and turn. 1 leg stand could not be performed due to the defendant stating he had a hip replacement. DIC red, consented to breath, 0.159, 0.150.
Garcia, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
Yes, I did.
Do you have a valid liability insurance in your name?
Yes, I did.
You run his license, please.
Of course.
I'm ordering you, and I am now putting a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. You will not get any more PR bonds. Do you understand? I don't care where you are. I don't care what planet you're on. If you drive a vehicle that doesn't have an interlock, you're going to stay with me. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Likewise, if I find that you're consuming alcohol or dope, you will go to jail. Where are you going now?
To work.
Where?
I work in the gallery.
You said you have a business trip.
Oh yes, to Austin. yes.
Okay, and how long is your business trip going to be?
I come back Monday.
Okay, so it's a short trip.
Yes.
Okay, understand that you're still under bond in this court, no matter where you go. So you have a lawyer. Good job on having a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Butler. He'll tell you if and when you have to come back to court. If he comes back to me and tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. I'll have you go to Victoria, sign a reset. We'll get you with Jeremiah for your bond conditions, and then you guys are free to go.
Thank you.
Okay.
Thank you, Your Honor.
Thanks, guys.
Have a seat.
Okay. Yeah.
Page 9, Miguel Garcia.
And an in-camera inspection for
Mark. I don't see it, do you? I did sign? Okay. Got it. Victoria, what did you say his name?
Page 9, Garcia.
Hey,
we need to approach on the signature. If we could just approach it.
this is an arraignment.
Yeah, of course.
Miguel Garcia. Tell me, are you ready?
Yes.
Okay, Mr. Garcia, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews in the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On April 7, 2024, officers were dispatched to 407 Ritchie Street in Pasadena, Harris County, Texas, for an assault in progress. A bystander flagged the officer down to report that someone had a firearm. The defendant was detained on scene and identified by the complainant. Complainant is defendant's brother, who stated that they were arguing after the defendant broke the complainant's car window and the defendant struck him with a closed fist, causing pain. The complainant did not want to press charges. A firearm was recovered underneath the vehicle that was parked next to the complainant's. Witness told officer defendant had a firearm in his hand during the argument.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. A protective order was issued on the 9th of this month. I suggest you get to know it. If you do something to violate the protective order, the state can and will file a violation of a protective order against you. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on one of those cases, I can hold you at no bond, zero bond, and I'll do it in a heartbeat. Do you understand?
Yes, sir.
How old are you?
18.
What do you do for a living?
Sorry. I work as a painter.
Apply for an appointed lawyer, sir.
No, I could get my own.
Sure.
Yes, sir.
If you have any issues, come back to me. Don't pick up any new cases. Otherwise, I'm going to keep you with me. You will not get any more PR bonds. Do you understand?
Yes, sir.
I'm ordering you as a condition of your bond not to be in possession of any weapons and not to have any contact with your brother for the time being. You violate these conditions, I'll keep you with me. I'm going to have you go to Victoria. We'll have you sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and you'll be free to go. All right, please. Last time you were here, I told you that you had 2 weeks, and when you came back, it was going to be a plea or trial setting. Your case is 745 days old. We set cases for trial at 180 days. You understand? It's time to make a decision. So, you have all the evidence, right?
Can I get a refresher on the name, Judge?
Yeah.
Just see the evidence.
I can't, it's not fair to everybody else.
Well, especially
So let them,
just coming into this case and just hearing that for the first time. My conversations with Mr. Young and his father were let me hop on the case, let me make an appearance in court, let me file the motion at least to notify the court that he has counsel at this time. I got an email from their office saying, look, this client's been approved for PTI. And I said, well, great, but then I was also under the impression that he had some other deal back when, he hired now Judge Melissa Morris. So I'm still trying to he's got an ankle monitor. There's all these pieces of the puzzle I'm trying to put together, and then you're telling me that, whatever the
That's
last
something that
conversation.
he should have told you, and at 750 days, it's something that we have to,
If it has been lingering, I understand, but I don't even know anything past, he's got the ankle monitor, and then the email I got from the DA's office saying, he's been approved for PTI. And so the only thing I think that's missing would be, he could do a walk-in TRAD if that's the route he wants to go, but I don't want you to hold it against him for me coming in and asking.
I'm not holding it. I am holding it against him because he's the one who's been gone for damn near 3 years. I love you, Matt, but
sure.
I can't, it's not fair to everybody else who actually does what they're supposed to do. And I don't let this happen to anyone else. It's so not fair, and I try to be fair to every single person.
And in giving that point, Judge, when I spoke with him and his father, when he hired the now judge, this motion that was filed to withdraw from the case, he did not even know about it until he said, somebody called him much later saying, hey, your attorney is now going to become a judge. She's getting off all the cases. And he said, well, I have a cleaning, he had all these questions. And then
it is your responsibility to go somewhere at that time and figure out what to do, not 700 days later. You've approved him for the PTI program?
Yeah, as of April 8th.
The only thing I will give to you now is we will send him, he's got to get the application done today.
Yes.
He goes for a TRAS today, and then he's got 2 weeks to get the interlock.
Okay.
And then that's it, and pay the DA fee within 2 weeks.
I mean, yeah, I can
If you can get everything done in 2 weeks, fine.
Sure.
I'll give you this, but I will not give you any more time. I'm going to set up a trial,
Okay.
and it will be set for trial in 2 weeks. If he doesn't have everything done, he will be put to trial.
Okay, that's fine, Judge.
In an effort to, but I promise you, Matt, I'm not going to give any more time than 2
I got
weeks.
that.
It's got to all be done within that time.
And I will speak with you.
If you ever take off again, I'm going to absolutely light you up. I have never done this before. Do you understand, Mr. Young?
Sir.
2 weeks. Okay.
So, here for John Harris. Briefly just spoke to him, just trying to get an idea of how I can help him get these cases disposed of. He's currently homeless, so I'm going to try to get him into the Harmony House and talk to Meg here. As soon as I go to another court, I shot a call to her. He's homeless, so I mean, this is where I'll stem. So I want to try to get him some housing, so he can get situated, so then we can try to get to a point. Criminal trespass, I mean, it's just the classic. And I've been in TCJ for a good few years, so.
Oh, what?
For robbery.
Come on, Mr. Harris. From where? From where? Here in Harris County?
I'm just telling you, I understand we're gonna walk together with this thing, and try to get into the Harmony House or something similar. And take care of our business.
I get your situation. I don't want to put you in jail, Mr. Harris, but you still have to follow the law. Do you understand? I'm not going to put up with this. I usually 99% of the time put people in jail for picking up a new case. I understand that you're trying to find a place to sleep. I don't want to ding you on that, but I'm not going to allow you to pick up case after case. Do you understand? You now have 2 open cases. You pick up a third, and I don't care what you're doing, where you're going, what your intentions are. You pick up a third case, it's over. I will put you in custody, and consider that if you don't have anyone to pony up $10,000 to $15,000 of a bond for you, you'll be stuck like Chuck. You understand? If you want to find a place to sleep, that there are proper places to go to. In where you went the last time is not the right place. Don't make any more bad decisions. You understand? All right. So you are not allowed to go back to this place. I don't want you in possession of any weapons. Trinidad can help you find a place, but going into someone else's house, someone else's private property, that's not the way. Do you mind filing that he can't do these things, please? You have Trinidad. It's your responsibility to stay in touch with him. If he comes back to me and tells me he can't get a hold of you because you're playing Helen Keller, I will revoke all your bonds and make them high. You understand, Mr. Harris? All right.
Appreciate it. Thank you.
Huh?
How can we deal with a warrant?
Yeah. Thank you. I forgot about that. I'll reinstate it.
Thank you, Your Honor.
Yeah, we issued the warrant.
I appreciate it. Thank you. Let me get this information.
It's your boy. So Victoria, he's got to sign bond conditions though.
Take a deep breath. Stand right here. Yes or no, sir? Okay, or yes, Your Honor, no, Your Honor. And just listen to what he's saying if you have any
So
questions.
the ag assault and the 2 peace officer assaults are all being dismissed?
Those are all being dismissed, Your Honor, as part of this plea deal.
This is a fantastic deal and I hope that you get it. You understand? What you must also understand, Mr. Francis, is that what you're doing is you're entering into a probation that's the next best thing to a dismissal. It's called deferred adjudication. You cannot tell people it was dismissed if you complete, though. It wasn't dismissed. You merely took a probation, completed it successfully, and did not end up with a conviction. Do you understand? Yes. You must also understand that you give up nearly every right known to man by entering into this agreement with me today. If you violate this, you authorize us to put you in jail for an entire year. Do you understand? Yes, sir. So if you pick up a new case, if you don't do your conditions on time, if you don't show up, if you test positive for dope or alcohol, these are conditions that will cause you to violate this. And what I will do, I will issue a warrant for arrest. I'm going to put you in jail. I will bring you out. The only thing that we're going to talk about is if you violated it, and if you did, how long of a jail sentence you're going to be doing. I will make this sweeter for you, though. If you can get everything done quick, I will take you off and have the time as a reward. I want you to do well, and as the proverbial carrot, I'll take you off and have the time. That means, number one, that you're nice to everybody. Don't make boneheaded decisions. Don't pick up a new case, and do what you're supposed to do. You understand? As part of the agreement, you will do what's called a TRAS. This is an evaluation to see what conditions you may need. You must fulfill all the conditions that are assessed. And you will also get on the mental health caseload. You will also have no drugs, no alcohol. So these are serious cases upstairs. Do we need to see whether there's no contact with certain people or not?
No, Judge, the aggravated assault case is being dismissed because it's not a righteous aggravated assault.
Okay.
So that's why that case is not an issue and why we're just moving forward on the 2 resisting cases. The TRAS was already conducted actually as well. I forgot to tell you that when he was in custody on the felony cases. So I don't know if we need to do another TRAS.
No.
We might just.
How long ago did you do it?
I ordered it immediately.
Just so you know, when he says we're doing stuff upstairs or with the case they have upstairs, that's that one judge I played this morning, or earlier, I should say. Oh God, she dismissed everything. I can't remember her name right now, but those are the cases upstairs. So once they leave this court, they go to the courtrooms upstairs. Now I just have to find which judges get his case, because there's a bunch of them I I gotta find. Hopefully we get another good judge upstairs too. We'll see. And Sally Port, if you can hear us, everybody's missing you.
Immediately.
It's only good for a year.
Okay,
So
it's been within a year, Your Honor.
do you remember what they said?
If he was released before, that's probably why.
Okay.
Didn't get completed. Okay, so you'll have to redo
We
it.
will have to do a new one.
Okay, so I would also, I'm gonna order you not to be in possession of any weapons as well. Don't have any weapons. Just follow what you're supposed to do. If you ever have a problem, come back here and we can help you out. Don't just stop showing up. That's the worst thing that you can do. You're giving.
And Your Honor, also just so that the court's aware, my client does have a history of mental health issues. This entire event was due to a mental health crisis that was ongoing. So that's why he is being placed on the mental health caseload as part of the probation. And I really have told him that I think needs to be the main focus of his probation, is just to focus on his mental health, and he'll be successful.
And we will help you with that, Mr. Francis, right? So let me ask you this. Are you taking any medication now?
So no, sir. And this is one of the conversations I was trying to have with my psychiatrist and my therapist, because so far as for me, I've been trying to keep in contact with them so I can kind of have more therapy appointments to kind of navigate some of the things that we have been addressing. And
are you supposed to be taking medication?
But that's been part of the conversation. Part of it, to be very honest with you, I've explained to him, so long as I've stayed away from any substances, my mental health is starting to get a lot better. Other side of the coin is like kind of having the epiphany of kind of realizing, oh, in sobriety, I can't be around certain people, that kind of thing.
That's right. When you hang with dogs, you get fleas. So how do we assure that you're not going to hang around with the wrong people again? Because 2 years is a very long time. I think that we should continue with that. Make that a condition as well, that you also must attend treatment as well, substance abuse treatment. Mr. Francis, you give up a lot of rights by entering into this agreement today. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is a contract that you and I are entering into now, and you will stick with this contract until you either complete it successfully or unless it gets revoked. Can you waive his fees in just in total? I will waive your fees for everything that I can. If they assess things that you have to do with third-party vendors, like any kind of treatment, or that's something that you're going to be responsible for, okay? But everything that I can pay for, I will. Like I said, if you have any problems, just come back to us, and counsel will also help you out as well. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold that for 2 years. So no drugs, no alcohol, random UA, substance abuse treatment, no weapons, and then the mental health caseload. And then that's it. In a T-rest, right?
Yes.
Yeah. Okay, guys. Thanks.
Thank you.
All right, we'll have you see.
Mr. Francis?
Just,
She's gonna talk to you.
yeah, not this approach. Yes, sir.
Hi. You ready? Okay. Do you mind bringing them up?
Yeah, the only issue I've had was my interpreter was not able to sign through the portal online. So if he needs to sign with the clerk.
Yes, we'll have to print it out so that they can sign. What is his last name?
Freddie.
Freddie.
the regular assault, and then we're pleading 9-month deferred on the indecent sexual, the misdemeanor sexual assault. Here, so come stand here.
Okay. So the assault's being dismissed, you said, right?
Yes.
Okay, and then we're going, did you say it's a 1-year deferred or what?
These are 9 months deferred.
9 months deferred. Okay, so who's going to translate? Okay, what is your name, sir?
Ganesh Chakal. Ganesh.
Ganesh? How do I spell that?
GANESH
Ganesh, like the god.
K-A-N?
GHAKAL.
L is the way?
A-K, the call.
Chakal.
D-H. Yeah.
65.
Okay, will you raise your right hand, Mr. Ganesh? Do you solemnly swear to translate word for word everything that transpires now?
Yeah, I do.
Okay, thank you. You may put your hand. Okay. You are Bal Opreti.
So pretty, yes.
You were charged with 2 cases.
Will I do like a slide? Yes.
You were charged with indecent assault and assault bodily injury.
Yes.
You have worked out an agreement where they're going to dismiss the assault and you are entering into a deferred adjudication with the indecent assault. The 9-month deferred is a probation.
Yes.
If you successfully complete, you do not end up with a conviction.
Yes.
You give up many rights by entering into this agreement. The right to have a trial, cross-examine witnesses, confront your accusers, you have the right to remain silent. Anything you say can be used against you. You give up all rights by entering into this agreement. Once you enter into this agreement, you cannot change it. This is a contract you and I are entering into. If you violate this agreement, you will be facing an entire year in jail. If you violate it, I will order your arrest and put you in jail.
Yes.
If I find that you violated your probation, we will have a hearing on how much time to put you in jail.
Probation, you don't contact money, probation nominal बिचमा और त्यस्तै कुरा केही भाइलेट गर्नु भएन त्यसपछि फेरि ट्रायल हुन्छ तपाईँको कति दिन जेल राख्नु त्यही भएन ट्रायल हुन्छ नमिना बिचमा केही भयो भने
Okay. It is a 9-month deferred. You will do an effective decision-making class.
त्यो गर्नुपर्ने हुन्छ तपाईँले क्लास अनलाइन क्लास हुन्छ इङ्ग्लिसमा लेख्नु होइन लेख्ने होइन त्यो हेर्ने बुझ्ने काउन्सिलिङ क्लास जस्तै हुन्छ
8 hours of community service.
8 घन्टाको कम्युनिटी सर्भिस भने अब कम्युनिटी सर्भिस
Both of those must be done in a limited amount of time.
13 टाइम भित्र गरिसक्नु पर्ने हुन्छ
You will also have no contact with Miranda Baradas.
No.
You understand what's expected of you?
Yes.
Is this what you want to do?
Yes, sir.
How do you plead to the offense of indecent assault? Guilty or not guilty?
Guilty one.
No, but you have to ask him how he
Say the
pleads.
way the judge said it.
Guilty.
No.
Ask him the question the judge says, how do you plead guilty or not guilty? Translate that.
तपाईँले अब गिल्टी हो कि होइन गिल्टी हो भन्नु त्यही अब यो कन्ट्र्याक्ट गरिसकेपछि गिल्टी भनेर अब अलिक हुँदैन क्या यो कन्ट्र्याक्ट गर्नको लागि एक्सेप्ट गर्नको लागि गिल्टी भन्नु पर्यो क्या तपाईँले
Guilty. Okay. Yes, sir. I will not find you guilty.
अब जजले चाहिँ तपाईँलाई गिल्टी फाइन गर्दैन
I will withhold the finding for 9 months.
Yes.
Okay? Like I said, if you complete it, no conviction. Do you have any questions? Okay. For now, if you can tell him, we will have him meet with our probation officer, and then you guys can get through the ordeal. Okay,
Your Honor,
thanks.
excuse.
Yes, ma'am.
That was interesting.
Yeah, for sure.
Oh, I didn't sign it, but he did.
What's up?
Customers on your docket this morning. First one is last name Garcia, Miranda.
Yes.
Okay, state made some new offers. She's still not interested.
Come up, Miss Miranda. Can you read me the, what's the cause number, please?
Cause number is 247-0176.
Okay. All right, Ms. Miranda, you were charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. The state has made 2 offers to you today. State, what have you offered?
Time served, which is officially 3 days behind jail, and then the 9-month deferred.
They're
Okay.
giving him time served.
They've
guys.
offered you 2 things.
Poor guy.
9-month deferred, which is type of probation that if you successfully complete, you don't end up with a conviction. They've also offered you time served where you plead guilty. They will offer you 3 days in jail. However, you have a sufficient amount of time that would credit that. So you basically walk out of here today. However, you would end up with a conviction on your record. Your case is old. It's time to make a decision now. I don't like to waste time, and I most certainly don't like to waste jurors' time. So if you want to set this case for trial, I'm happy to accommodate you, but I will not accept any plea bargain offers on the day of trial. You must make that decision today. If you want to make a decision today, wonderful. If not, if you will continue with trial, that's okay. But I will not take any deals on, we will actually go to trial. I don't want you to make a decision now. I'll let you guys talk about it. You make a decision, tell me what you want to do. But I'm telling you, once you set this case for trial, and this is going in 2 weeks on the 30th, We will go to trial. I don't care if anyone is kicking or pleading or screaming. I will have a jury here waiting for you. Okay? All right.
All right, we're pushing on one case, out of theirs, is it? Am I correct?
Yes. Okay.
Okay, so, out of this case, Your Honor, this is one of the most forthcoming clients that I've had. Told me yesterday that he tested positive for marijuana and cocaine.
Correct.
It's a off and on history since, 2000, for years. He wants some type of treatment. He wants to address that and get his life back on track. So I'm not sure, I know you said some things that we wanted to discuss, but I wanted to put that out, that he's seeking some type of treatment, he's willing to go.
What does he do for a living?
He doesn't work.
He don't do anything
His
for a
brother
living?
cares for him and he stays with his grandmother.
Oh.
He has a 10-year-old daughter.
Come up. You don't work. Therein lies the problem. When you have too much time on your hands, you become self-destructive. You need to find something to occupy your time. And the good thing that when you do, the byproduct of that is that you get money. How are you getting money now? Because cocaine is not something that's cheap. That's the problem. Because at some point, if you steal from the wrong person, they're really going to stick it to you. And you live in Houston. This is not Montana. This is not Wyoming where you can get away with things. I'm telling you, you muck with the wrong person like this BMV, they're liable to shoot you dead. We had one not weeks ago where a person was killed for committing a BMV. Now, you don't have health insurance, do you? I don't know how we could possibly, the only thing that I would suggest is that we're going to have you, how did you get here today?
The light road.
How far do you live from here?
Here's not far, like 5 miles. I mean, like, just a couple miles.
The problem is that if I have him test on a particular day, he can evade from us, right? He can, because cocaine only stays in your system 3 days, 4 days at the max. So I can have him test on multiple days, but that will require him to come up here. We can have him do AA, NA classes, which is cheap. It's virtually free because you can do it online, but I would need proof of attendance. Without health insurance, there's
Offer, right? Let's see.
if we were to enter into some kind of agreement, then that's something that I could pay for. But short of that, there's nothing that I can really pay for. Give me a second. Let me make a phone call. Just Gary's. Hold on a second. Hey. Gary, it's David Fleischer in Court 5. Hey, I got a question for you. I got a gentleman in front of me now that we would like to do some kind of treatment program. But dude ain't got no money, no health insurance. Is there a workaround for that? Yes, that's it.
So, you know, Salvation Army has that program called the ART program.
Okay. I'm bond.
ART program is really good. You give it a few minutes there and I can look it up and send y'all the information.
That'd be wonderful. Yeah, please.
The ART program is really good. It's a residential.
Okay.
They may allow
Mm.
yeah, they're actually, you know,
It paid for?
yeah, they're paid for.
Wow. Well, that's wonderful. So he don't have to shell out a dime.
We won't have to do anything, but he just has to go there and meet their criteria. I can send you all the police.
Yeah. And what, is that the only thing that you know about? Or anything else?
That's the only one that I know of. But if you want to have it determined to reach out to me, I can find, I'm actually not in the office today, but if you want to have his attorney reach out to me,
Okay. So for now, I'm going to have him, I guess, come here, test a couple times a week until we can get something like this going. And then I'll give it. Yeah, that'd be great. Yeah, wonderful. You'll be here in court then? Okay. Okay. All right. Thanks. Okay. Okay, thank you, Gary. There's a program that's administered through the Salvation Army. It's called the ARC program. That's something that'll pay for him. But the only problem is this is residential.
Okay.
So I don't know if that's something that he's going to be willing to do, you know?
We talked about inpatient, so yes.
And it's free. It's not going to cost you a dime. So what we'll do now, until I can get him in, I'm going to have him come twice a week to test. Don't use. Otherwise, I'm going to put you in jail and I'm going to give you the program in the jail. This is the way now that you have to stay out of jail. You understand? You will only get this one chance from me. I will not give you another PR bond. I also want you to start attending NA classes 3 times a week online. You should be able to do it free. And I want proof that you've done it. You understand? I want you to bring me proof here every time you come here to show me that you've done it. A piece of paper showing the day you did it, the time you did it, where you did it, and the person who you did it with. Do you understand, Mr. Olivares? And if you don't, you're going to be staying with me. I will have you do this until we get you into a treatment program, which I'm going to work on now to get you in. Do you have any questions? Don't pick up any new cases. That's about the worst thing that you can do. There's no quicker way for you to go to jail than to pick up a new case that involves a theft, a drug case, or anything like that. Give me questions. Okay. I have also given you Ms. Hayes. She's great. It's your responsibility to stay in touch with her. If she comes back to me and tells me she can't get a hold of you because you're playing games, likewise, I will issue a warrant. Are we good? Okay, just go ahead and take your seat for me. We'll get back to you.
I had a question.
He just left, like literally just now.
Okay, thank you.
So, okay, Vera is good to go, so it's just now.
Judge, ready to go ahead?
Yeah.
Page 4, day.
What day got arrested? May
Wrong day. 2501.
I want to meet that.
Next one, page 9 and 10. Mark.
Here with videos and I have one of those. Some chorizo, some seasoning or something. Oh, that's fine. Oh, yeah, that's good. Louise.
He took a plea in the.
Yeah, but the place is 250 miles away, so we got like 411.
What's it?
East Avenal. The west.
Nothing happens here. I just got the lollipop.
5,002 on both. Hey, are you guys ready?
No, sir. The state had to refile the paperwork, so gotta make sure the second set goes through.
Page 13.
Oh, nobody else.
I'll buy some. I don't think I ever went to raffles in a year. I'm not gonna chance it. How much is one? What's that come down to for
All right, I didn't know I got that much of the lollipop.
I don't think so.
I don't know. But I'm gonna get him out here and I'll talk to him. It's just, it's like everything is pointing to us, nothing.
Okay.
After this, I got.
All right, who's after Gerard?
Yeah, you make an ulcer around.
Who's after Gerard?
Page 13, Julian, Jeremiah.
It's generic, like medium size amount.
Yeah.
So.
2501.
Tulip, same thing however you want, and then you kind of get wet.
Page 14, Lopez, Javier.
Interesting. I want to try a project like that. I've made my own bullets. I've modified them. I've never made a bullet.
See, I've never made my own bullets. Like, that's the question.
Yeah, it's fine. Yeah, well, it's easy once you get used to it.
Getting in this court is a bit of a privilege.
There we go. Now we're on track.
We ask you to answer truthfully but briefly, and keep in mind that what you're getting in this court is a bit of a privilege, okay? And he will yank it away the moment you mess up, and no matter how small it is, okay?
I don't know that I'm gonna take this. Let's go through your stuff, Mr. Robinson.
Sir, no, sir.
Yes, sir.
This case has been open since 2022. You failed to appear October 4th, 22. April of 23. October of 23. Again in October, you failed to appear. We had to revoke and raise your bond. So a total of 1, 2, 3, 4, 5 times you absconded. And now the only reason we have you is because you picked up a felony violation of a bond condition or a stalking case. And you want me to accept a probation on you? In what alternate reality do you live in, Mr. Robinson, that you actually think that you're going to be able to successfully complete this? Not only do you have all this looming, but you live in Liberty County, which is about an hour or more away. Tell me, why on earth would we take this probation?
Check in. I have the means of transportation.
You never did before.
The judge is more concerned about your willingness to participate than your.
Well, I have a daughter now. I didn't have a daughter.
How on earth could you take care of a daughter when you can't even take care of yourself? You're in jail, man. Who's taking care of that daughter? Really? Really? When is the last time
She's a great mom.
When is the last time you've even had a full-time job?
I had plenty of full-time jobs. I had a full-time job before coming in here. I was working as a security officer.
That's cute.
I'm not smart, sir. Being honest.
All right.
I was also working at Dollar General in Dallas or Aubrey, Texas.
I'm not convinced, Mr. Robinson, because
Yes, sir.
I don't think that you're going to make it.
Yes, sir.
Why are we going to waste our time when If history is any indication, you're going to get out there and you're going to do absolutely nothing.
Oh, almost.
What you have to remember is that this life is but one that you have. This journey can be a wonderful journey where you get to hang out with friends, family, get to go on vacations, or it can be a rotten, miserable toilet of an experience where you're in and out of jail, prison, scraping to get by. Most divorces happen because people have no money. And that happens because you go to jail because why? You have absolutely no self-control. Against my better judgment, I will give you a chance because everybody deserves at least one chance. But I'm going to tell you now, you muck with me, I'm going to light you up. I am putting an ankle monitor so where I know where you are at all times. You will report directly to me. You will not report to anyone else. And I'm going to make sure that you're not consuming alcohol or drugs, and I want you to test with me. And I'm going to tell you now, you entering into this agreement, you muck this thing up. You're looking at an entire year, and I will do it in a heartbeat to protect the public so that you finally get we mean business in the criminal justice system. You understand, Mr. Robinson? Sure.
Yes, sir. I'm sorry. Yes, sir, I do.
No.
The way I would phrase this is you're on a short leash. With that leash, it's just long enough for you to hang yourself. All right?
Expect to do a batter's intervention prevention program that is 18 weeks, one time a week for 18 weeks. The other thing that you must understand, Mr. Robinson, is that this comes with an affirmative finding of family violence. You ever pick up another case like this again, where you so much as grab someone's arm and yank it where it hurts even the slightest, you will be facing another third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You'll never own another gun or ammunition as a result of what's going down today as well. You understand?
Yes, sir.
This is a probation that if you successfully complete, you do not end up with a conviction on your record. There is still an affirmative finding of family violence, which the consequence I've just advised you. If you complete this successfully, you do not end up with a conviction on your record, but it's not dismissed. You cannot tell people it's dismissed. If you violate this probation, I will order your arrest. I will put you in jail. I'm going to bring you out like you are in Orange now. The only hearing that we're going to have is whether you violated this probation. You will be looking at a year in jail on this case if you violate it. No drugs, no alcohol, no weapons, no contact with the complaining witness in this case. And I'm going to test you like crazy, just so you know. If you want this, I'm going to make you work for it. And if you so much as step off it wrong, there's going to be HE double hockey sticks to pay. Do you understand? Are you sure you want to do this?
Really, there's not much of one. We could plead.
Yes, sir.
and-
Sure.
Well, have they offered time served?
So the problem becomes, Judge, is we have the interplay of the felony and the misdemeanor. So felony wants them to be monitored. So if the two cases were separate and there was no felony, I'm sure we could work out a shorter jail sentence than a year. But in order to receive the plea upstairs on the.
I'm okay doing this. If you do this, I want you to know that we mean business. You understand, Mr. Officer? I'm not going to play games with you like this last time where you took off 5 times. The first time, that's it. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will reluctantly withhold that for 2 years. You do this well, you won't end up with a conviction. You don't do this well, I'm going to put you over my knee and I'm going to spank you like a little child with a ton of jail time. Do you understand? Just like a little child, because you are one of mine now.
Like a child, it will both be harsh and quick. Thank you, Judge. All right.
Right this way.
And with that, it's a wrap.
And with that, it's a wrap. And with that, it is a wrap. Oh my goodness. Yeah. Someone, who was it? Was that you, Cloud, who said earlier about a spanking in chat? Oh man. The lawyers laugh at him a lot. But my question is, okay, so we've been watching a lot of these videos, right? Okay, you see the guy who's about to get a spanking standing there, and look right behind him. There's that guy sitting at the table across from where the prosecutor. Yes, guys, there is a prosecutor in this courtroom. He doesn't do much because the judge does it, but there is a prosecutor in there. Or is that guy in like the light blue shirt? What is his job? What does he do? Every time I watch now, I watch for that guy to see what he does, and I can't figure it out. So I've been thinking about bingo a lot lately because it's fun. It is fun. So what I think I'm going to do, I think we need a few more subscribers first, but I think I'm going to print off court bingo cards. Just nothing fancy, just like little sheets of paper or court bingo cards, and put them on my Patreon, right? I think I can put them there. I don't know. Real cheap. And then any proceeds from people buying a bingo card will go to a prize. And if you get bingo, you get a prize. I don't know how that's going to work. It'll be something small and stupid. But that'll be fun. We could sit here, we could play bingo every video. And I'll put the regular standard things on the bingo card. Irritable bowel syndrome. Grandmother has a exam to take in college, so I can't be in jail. I don't know. It'll be fun. I'll get some good ones. I gotta think it through. Do it on Discord. Can you sell things on Discord? I'll do it somewhere. Don't worry. No, I got the IRS. Don't worry. Promise notes, spankings, yes, and lollipops. Spankings and lollipops. Oh man. All right, guys. I'm gonna go. See, I'm on break right now. When I finally get to play the videos, I'm on break. But once the videos are over, then I have to get back to work again. Yeah, and we still miss Sally. Did Lightfoot come in today? I didn't see Lightfoot. Lightfoot, hello. Miss Glow, hello. B24 Liberator, hello. I'm just saying hello to people who can't make it to my lives. Danny. Not you, Danny, the other Danny. There might even be 2 other Dannys. That's a wrap. Stuck like Chuck. Yeah, bumper stickers. Oh, that's right. It is gambling, isn't it? Nah, because you guys are buying bingo cards. Wait, is it gambling? IRS gonna get me for that? Because if the IRS is going to get me for that. They will get me for that. I will not be able to squeak away from that. All right. I will look into it more. Just thinking. Thanks for all the new people catching it live. I appreciate it. Thank you everybody for coming out. Thank you mods for doing the best job ever. I am a professional. Sorry for the loud Mahjong music in the middle of the video, but I'm on break, guys. I'm on break. Yeah, churches do bingo. Maybe I'll make a church first. Okay, guys. Hi, Deb. That's it, guys. That's it. I'm going to create a church. I'm going to create a church. I'm going to register it, and then I can do bingo, and I won't go to jail. This plan cannot fail. It just can't. See you later, guys. Have a good day. Love you, Cloud.